Sunday, February 8th. What began as a conventional legal dispute has now escalated into something far more severe, an active federal manhunt. A federal judge has formally authorized the United States Marshals Service to take action against Ivanka Trump. This is no longer speculative or symbolic. The case involves the seizure of $47.3 million, a documented trail of 127 evidentiary exhibits, and a prison sentence that is no longer hypothetical. It is live, enforceable, and unfolding in real time. The speed of escalation is alarming. On Thursday, the critical court filing was entered into the docket. By Friday, U.S. Marshals were mobilized. By Saturday, the Trump family's entire public-facing operation went silent. In just 3 days, the situation spiraled beyond control. According to filings in the Southern District of New York, Ivanka Trump failed to comply with a court-ordered self-surrender deadline. That alone is serious, but the truly unexpected development involves Melania Trump. When pressed by legal counsel to provide standard character testimony that could have materially reduced Ivanka's sentence, Melania didn't simply hesitate, she refused, publicly, on the record. As for Donald Trump's response, I'll walk through it carefully because I've spent hours reviewing the filings myself. But before we break down the documents, understand this. Events are moving faster than full reports can be produced. For raw, unfiltered updates, details too sensitive or too fast-moving for traditional coverage, I've been posting everything to my private WhatsApp channel. That's where developments appear before mainstream media catches up. The link is in the description. Now, the context. Ivanka Trump, the former senior White House advisor, daughter of a U.S. president and wife of Jared Kushner, is the central figure. The core charges are financial fraud and obstruction of justice, tied directly to foreign business transactions conducted while her father occupied the Oval Office. Here is the compressed timeline. Months ago, federal investigators issued subpoenas for financial records connected to a $340 million real estate project in Dubai. Weeks later, a grand jury returned a 7-count indictment. Last month, a jury convicted Ivanka Trump on 5 of those counts. The sentence was explicit: 36 months in federal prison with an order for voluntary surrender. She did not appear. That failure changed everything. The presiding judge, appointed during the Obama administration, a fact critics are now loudly emphasizing, issued a bench warrant almost immediately. By Thursday, that warrant escalated into a full directive authorizing the U.S. Marshals Service to act. This is where the narrative becomes chaotic. Melania Trump was subpoenaed as a character witness, a routine step in sentencing and appeal proceedings. Family members almost always testify in support of the defendant. Melania appeared for her deposition and read a prepared statement, but when asked directly whether she would vouch for Ivanka's character, her response was stark. She stated, "I am not in a position to provide that testimony." Those are her words, not interpretation. The transcript speaks for itself. Now let's examine the evidence. The first filing, entered Thursday, February 5th, contains critical language on page 23. Defendant Ivanka Marie Trump failed to present herself at FCI Danbury as ordered by this court, constituting willful non-compliance with a lawful judicial mandate. In plain terms, she ignored her prison surrender order. That is contempt of court. But the detail that truly stands out appears later, on page 47. In a separate section, prosecutors reference wire transfers totaling $18.2 million. These funds were routed through a Wyoming-based LLC that was registered exactly 3 days before the original indictment was issued. 3 days. That timing is not incidental. The LLC was formed in January 2025. The $18.2 million moved within 72 hours of its creation. FinCEN flagged the account, yet, for reasons still unexplained, it was never frozen. All of this is now documented. Then there's Exhibit F, buried deep in the appendix on page 89. Communication logs show 31 text messages exchanged between Ivanka Trump and a phone number traced to a former Secret Service detail. These messages were sent the night before her surrender deadline and later deleted. Prosecutors recovered them. One message, timestamped 11:47 p.m., reads, "Package ready, route confirmed." Prosecutors argue this suggests preparation for flight. The defense claims it referred to moving belongings. Decide for yourself which explanation fits the timeline. The second critical document is Melania Trump's deposition, filed Friday. It spans 67 pages. Page 34, lines 4 through 11, contain the moment everything shifts. When asked whether Ivanka Trump respects the rule of law, Melania responded, "I would characterize her as someone who protects her interests." When pressed for a yes or no answer, she replied, "That is my answer." The testimony grows more damaging. On page 51, Melania confirms attending a 2024 dinner where Ivanka allegedly discussed contingency plans if legal proceedings went badly. When asked what she understood that to mean, Melania said, "I understood it to mean what it sounded like." The judge cited this testimony directly in his escalation order. He wrote, "The defendant's own family members have provided testimony suggesting pre-planned non-compliance. As a result, the marshals are authorized to use necessary means." The $500,000 bond was forfeited. Additional charges related to flight risk were placed under review within 48 hours. Donald Trump's response came Saturday morning via Truth Social, followed by a formal statement through counsel. He accused the judge of corruption, labeled the U.S. Marshals Biden's Gestapo, and claimed Melania's testimony was taken out of context. But notice what he did not address. No denial of the LLC transfers. No explanation of the deleted texts. No disclosure of Ivanka's location. The defense argues selective prosecution and political motivation, and some points deserve consideration. The judge donated $2,700 to Democratic campaigns in 2018 and 2020. The case originates from SDNY, an office that has repeatedly pursued Trump affiliates. Comparable cases have ended in fines, not prison. Even Rod Rosenstein questioned proportionality. Alan Dershowitz acknowledged the obstruction standard was unusually low. Two jurors later claimed they felt external pressure. These are not imaginary arguments. But then comes the problem: running. On Thursday afternoon, an emergency sealed hearing was convened. By 5:47 p.m., the judge found probable cause that Ivanka Trump was actively evading custody. Marshals were activated within the hour, known properties were searched, private aviation records subpoenaed, border agencies alerted. Then another development. Jared Kushner was seen Friday morning boarding a private jet to the Bahamas, alone, according to the manifest. A second plane departed Saturday under a sealed flight plan, registered to a newly formed Montana LLC. That same evening, the judge added a new docket item: inquiry into aiding and abetting a fugitive, naming Jared Kushner as a person of interest. Legal experts are blunt. Flight after conviction is a separate felony. Everyday missing compounds exposure. Even Trump-friendly analysts agree this was catastrophic strategy. Markets reacted. Trump media dropped 14%. Investors hate uncertainty, and this is uncertainty on steroids. There is no precedent for marshals actively pursuing a presidential family member. None. The implications will ripple through future white-collar cases nationwide. And here's the uncomfortable truth. If a billionaire's daughter can disappear while ordinary defendants are jailed within hours, the system's imbalance becomes undeniable. Tuesday, February 10th, is the next inflection point. That's when Judge Hayes reviews fugitive recovery and potential aiding charges. Thursday, February 12th, the Secret Service director testifies before Congress. Friday, February 13th, Kushner's response deadline looms. As of now, Ivanka Trump's location is unknown. She holds fugitive status. Donald Trump is posting. Melania Trump is silent. Jared Kushner is represented but uncharged. U.S. Marshals remain in active pursuit. This looks like chaos and family drama on the surface. Underneath, it is the legal system moving methodically, documenting every step. A family long accustomed to immunity is discovering that consequences may finally apply. The story is not over. The filings are coming, and when they do, they will be read line by line on the record.